Good morning. This is Taxsutra and BMR joint report on the IFA 2015 Congress, which is being held in Basel, Switzerland. The first scientific topic that got discussed today in the morning session here at the IFA was on the R&D incentives.
It's been a very interesting session, and the plan was to start off with talking about the need for R&D credits and the need for balancing the spillover effects on the economy with the loss of the revenue, and then the session moved on to the legal aspect.
What was discussed was that most countries do give R&D incentives even to the permanent establishments established by the foreign companies in their countries. And there are very minimal exceptions such as South Korea and India, where the local R&D incentives are not extended to the permanent establishments. Besides this, there was also discussion on how the R&D incentives interplay with the tax treaties. And there has been reluctance on the part of many countries to incorporate the non-discrimination article in the domestic law. Wherever there is a dispute on whether these R&D incentives can prevail, the local R&D incentives can remain discriminatory in favor of the local residents, then generally many countries have taken an approach that they should be able to give the effect as per their domestic laws and not necessarily extend the non-discrimination provisions of the tax treaty to the domestic laws. It was also discussed that there has been a global trend in shift from the enhanced deductions to more towards R&D tax credits, and that just seems to be more driven from the fact that it is easier to manage the credits rather than give the deductions, which invariably lead to double dip situations depending upon the country where the principal entity is located and the other country where the R&D is being contracted to.
With respect to the deductions versus the tax credit, what was also discussed that probably under the treaties, under Article 24(4), while there is a provision which allows deductibility of expenses, but it does not really take into account situations where countries are giving tax credits, or secondly, if there is an enhanced deduction, for example, in the case of India, 125% deduction is available in certain cases. There is lack of clarity as to whether this deduction could be available under 24(4) as well. However, more or less a consensus was derived that at least the non-discrimination clause does permit more and more PEs to get deductibility and incentives for R&D, except in certain cases, for example, Korea and India, where there may still be some issues in granting the credits. The proportionality principle was discussed, and the proportionality principle is really important because there needs to be a proper balance which needs to be strived between the need for granting the R&D credits or the incentives and the spillover effects on economy, because while on the one hand there may be a loss of revenue, but on the other there would be a positive spillover effect on the economy. It was also discussed that R&D incentives should be given irrespective of the form of the entity, irrespective of whether the R&Ds are patented or they are not, and an interesting discussion on the BEPS proposal also followed. The first half of the discussion rounded up with certain EU discussion related aspects and how the EU principles could still have an effect on the overall policy for granting R&D incentives.
So there was a discussion on the EU state aid rules and how certain patent box regimes have been under scrutiny by the European Commission. And there is this proposal which was put forward by the European Commission in 2011 in relation to common corporate tax base, which they call as CCTB. And it was also acknowledged that there is no provision for R&D credits or R&D incentives in this CCTB proposal. But there has been a revised proposal, which is a 2015 proposal, which is more optional. And it is left open whether some of the local countries might have the flexibility to give R&D credits under that regime.